Hello, Stuart Richland here from 420 Law Office and here on the YouTube channel. So glad that you've joined me today. Here's a little update as we sit at the end of March 2014. The League of Cities and the police chiefs have gotten together. State Senator Lou Correa from Santa Ana, a town that has banned pot dispensaries and really has not extended the kind of compassion that I would have liked to have seen, has put forth a bill that will really be bad luck for medical marijuana. It's going to try to muzzle doctors by limiting their ability to recommend medical marijuana and forcing that activity on the primary care physicians of patients. But unfortunately, those are people who are under a lot of pressure due to the groups that they work for, and so they haven't been able to do the simple act of recommending, which is really a First Amendment and a constitutionally protected thing, as is the doctor-patient relationship. But the general care physicians are often not very knowledgeable about medical marijuana. And Korea's bill and a series of other bills that have come together are really designed to try to destroy medical marijuana as we know it here in California. But that's not what this edition is really all about. I wanted to mention that I'm now at a stage of going to the Court of Appeal on our litigation versus the City of Los Angeles. That the recent development has been that although the plaintiffs put forth multiple theories and a 100-plus page complaint, that the judge, Judge Hogue, sitting in Department 322, she ruled that there was no cause of action stated in the complaint, and she refused even to grant us leave to amend, which is customary. So without leave to amend, she brought us to the inevitable, which is that we need a court of appeal to review her rulings in general, in the sense that if we do get a turnover of this ruling, we will be able to ask her to set aside, due to the rules on getting a new judge. There is a writ process for asking for a new judge, and it's applicable when that judge has been turned over on appeal. So hopefully the Court of Appeal will take note of the fact that unfortunately Judge Hogue referenced some items in her discussion of our complaint that were not in there. I think that there was some confusion, probably by her clerk, about whether or not our complaint had named a particular code section that is actually a charter section of the City of Los Angeles Charter, and whether we had gone into the specifics of that. And I tried to point out in oral argument that no, we discovered some of that information during the course of investigation after filing the complaint, and therefore we would like to have an opportunity to insert that material now. But instead the judge, I think mistakenly, thought that she was remembering that that was already in there. I think she might have been referencing the motions that we brought. In any event, we offered the judge, by request for reconsideration, another chance to look at it. As far as I know, that time is still ticking, but if we don't get reconsideration, the next step is to file our notice of appeal. Hopefully we'll there get some objective people to look at that situation, reverse the erroneous ruling in 322, and then we will get a new judge. In the meantime, though, one of the main things that I'm doing is generating interest in that appeal. Even though you may not be a party to the lawsuit, it is perfectly legal for you and your collective to support that appeal. And right now it is a cost limiting item. Without enough clients and or backers, there will not be an appeal. And then Proposition D will certainly remain the law of the land. Probably through 2016, because we don't anticipate that there will be a legalization or any other change in 2014. Although there is something going around for signatures, which I happily co-wrote, it's terribly underfunded. The reason for that is the Democratic Party in particular is planning to use the marijuana issue in the 2016 election as a way to generate votes and voter turnout. Unfortunately, this politicking will leave a lot of people out of jobs and even arrested, problems with their kids, their child care arrangements, and their right to custody. All kinds of terrible things are happening in the name of this prohibition against medical and other marijuana. And the contraction of marijuana rights at this time is certainly disappointing. California was once a leader, and now we're a follower in the area of medical marijuana. Even our own governor, whose party, the Democratic Party, endorses legalization in its platform for 2014, our own Governor Jerry Brown has changed his mind on marijuana. He wrote the guidelines in 2007 for medical marijuana, but now he doesn't want legalization. That means as the chief law enforcement agent really in the state, as the head of the executive branch, he wants to continue to arrest people for marijuana, and I think that's a crime and a shame. Well, if you're interested in backing and getting involved with this appeal, please call me. My numbers are all around the web. And if you would like to find out about medical marijuana law, the federal, state, and local law, how it works, and learn about the defenses, the caregiver defense, the individual defense, and the co-op collective defenses here in the state of California, just give me a call, and I'll be very happy to book an appointment with you here and go over the law with you. All right, take a look at my site if you're interested in that. That's 420lawoffice.com. Check out Legal Team Fights Prop D on Google. This is my book that I use in connection with my $500 consultation here in my office. It takes an hour. The book is 108 pages, constantly revised. This is the 9th edition. I look forward to reviewing federal, state, and local law with you. Just give me a call and I'll be happy to book your appointment.